Well, good morning, everyone. It's so good to see so many of you logging in. I can still see the numbers going up from my end. So great to see you all here today. Welcome to you all. And thank you for joining today's webinar. It's an employment law update. We'll be going through the Employment Rights Bill and the 6-step process. Park City have designed a 6-step compliance plan to save you the work of having to produce one yourself. So that's a freebie right off the bat. So I'm Juliette Price, and I've been working in HR and employment law for over 30 years. I'm really proud to be the founder and managing director of Park City Consulting. And we're here to help businesses just like yours to stay compliant and grow with confidence. Let me start by asking you a question. Please use the React button at the top of the webinar. So let me start by asking you this question. How confident do you feel about navigating the biggest changes to employment law that we've seen in a generation? Because that's exactly what we're going to tackle today. So please use your React buttons. Tell us how you feel about that. Some thumbs up. Any other reactions? Thumbs up. Okay, so everyone's feeling a bit, some are feeling good, but quite a few people are feeling a bit shocked and a bit concerned. Well, don't worry, that's exactly what we're going to tackle today. When I first started my HR career back in the 1990s, I thought I'd landed my dream role. After working my way up in retail, I was finally promoted to a personnel manager. And let me tell you, it was full on. One day I was managing a personality clash between the sales and finance managers, and the next I was dealing with an employee who felt bullied by their supervisor. Every day was firefighting, and every day firefighting something new. But here's the thing. While I was holding it all together in the day, at 5:30 p.m, when everyone else was heading home, I was driving from Colchester to Ipswich to college twice a week to study for my CIPD qualification. You can see a very embarrassing picture there of me collecting my CIPD qualification because weekends were filled with assignments, and after a few years of sheer grit, there I am proudly collecting and achieving my level 7 CIPD with merits and distinctions. Now, maybe you can relate to how I felt back then. I was stretched thin, constantly busy, trying to balance urgent employee issues with the need to keep contracts and policies and your handbooks up to date. And honestly, it was exhausting. I felt exactly how you probably feel right now. That pressure of always being behind on compliance because you're consumed with the day-to-day. And what I found was that if I'd had the option to outsource those updates to a trusted business partner, I would have jumped at it without hesitation. And I began to notice something else. It wasn't just HR managers who were struggling. Business owners and directors, friends and contacts of mine were coming to me saying, Juliette, could you just write me a contract of employment? Could you just draft a disciplinary policy? Can you advise me on this staff issue? And that's when the light bulb went on. I realised there was a real gap. Businesses of all size needed HR expertise, but they didn't always need someone full-time. They needed it as and when, and they needed it to be reliable. And that's how Park City was born. Today, we partner with SMEs and larger businesses across the UK. We're their extended HR and health and safety team, the ones who keep them compliant, reduce their risk, and free up their time to focus on growth. And our clients tell us that we're their business champion, more than just a provider. We've helped them handle grievances, complex disciplinaries, leadership challenges, and restructures. And at the same time, building stronger, much more confident managers and leadership teams. And why am I sharing this with you now? Well, because the timing couldn't be more important. Between 2025 and 2027, we're facing one of the biggest overhauls in employment law in a generation. The changes are deep, complex, and they impact every business, not just the corporates with big in-house teams, but small family businesses and growing businesses just like yours. That's why more and more businesses are turning to us for help. And that's why today, in this webinar, I'll not only give you the employment law update that you need, I'll share real client example, and I'll also introduce you to the Park City 6-step compliance plan, where we've done that planning for you. And it's a proven framework to help you manage these changes with confidence. And that's free. There'll be a QR code that you can scan. So if you're feeling stretched and unsure how to navigate what's coming, you're in exactly the right place. Here's what we're going to cover today. So the Employment Rights Bill, the government have set out their roadmap. I will cover it for you and put it into a straightforward process for you. I'm going to walk you through what's in the bill and what's coming. And then, as I said, our 6-step framework. These are the steps you need to take in your business right now. Okay, so the Employment Rights Bill and the government roadmap. So the Employment Rights Bill, as you know, was first put before Parliament on the 24th of October 2024. It's now gone through amendments following the conclusion of the committee stage of the bill. As a result of the committee stage, over the next 2 years, UK employers will be facing one of the most significant waves of employment law reform in decades. Most of the changes will come into effect in the usual April and October windows. Okay, there'll be some immediate changes this year, and there'll be some next year, and then some will follow in 2027. So why are we talking about it now, and why is it important to keep up to date? How's it going to impact your business? Well, as business owners, directors, and HR managers, I know there's lots of all of you on there, you already have enough on your plate. I feel your pain. You're running the business, managing the teams, keeping day-to-day operations on track. And the risk, if you don't prepare now, is you could face higher costs, legal claims, and simply very unnecessary business disruption. And that's why Park City have created our 6-step process. It's a 6-step compliance plan. It's going to help you, give you a solution to managing these things. It's a practical, proven way to keep you compliant, protect your business, and give you confidence as these changes roll out. The last thing business needs is uncertainty at this moment in time. We all need to be confident pushing ahead. Okay, so what's happening now? Let's move on to autumn 2025. So right now, autumn 2025, this is when the consultations of the bill are being launched. So the government have launched consultations on their key headlines. You've seen them in the papers, heard them on the news. Things like reinstating the school support staff negotiating body, establishing fair pay agreements in adult social care sectors, giving employees protection from unfair dismissal from day one of employment, along with a package of trade union measures and enhanced protection for pregnant employees from dismissal. So there's a lot there that's being consulted on right now. Okay, there'll be further consultations at the beginning of 2026. But now let's run through what the changes are and what's coming into force. So let's go through some of the process. So on the day that the Employment Rights Bill receives royal assent, so that's when it gets signed off by the King, that's going to happen in October. So that's next month. Okay, then it'll become Employment Rights Act. And at that point, the Strikes Minimum Service Levels Act will officially be no longer law. Now, you may remember this act requires workers to provide a certain level of service during a strike action in sectors like health and education. This will be gone. Most of the Trade Union Act 2016 will also be gone. And there'll be significant changes to any of the remaining parts. That includes things like strengthening protection from dismissal for striking workers, etc. Okay, let's look at what's coming in April next year. So these are the urgent and important things. So what major laws are expected in April 26? So next slide, please, Izzy. Okay, so we've got the day one rights are coming in April next year. So first of all, paternity leave. Now, as you know, currently, to be eligible for paternity leave, an employee must have at least 26 weeks continuous service. The new law in April will provide paternity leave from their first day of employment. In addition to that, parental leave. So currently, to be eligible for unpaid parental leave, the employee must have at least 1 year of continuous service. The new law will provide unpaid parental leave from the first day of their employment. So they can start working for you from the 2nd of April, and straight away they could put in a request for paternity or parental leave. Okay, the next one is sexual harassment. So sexual harassment, this is the whistleblowing part. So currently there's no protection for workers that raise the alarm. This is someone that believes sexual harassment has taken place. The new law adds sexual harassment to the current list of qualifying disclosures in the law, which means that the employee, the whistleblowing employee, that blows the whistle that says sexual harassment has occurred, is occurring, or is likely to occur, they will be protected from detriment or dismissal. Okay, so that's new and quite a significant addition to what came in last April on sexual harassment. There's more on sexual harassment, so we'll cover some more as we go further in. The next one that's very significant is statutory sick pay. So obviously this will affect all organisations, whether you employ one person or 1,000 people. So statutory sick pay, currently, as you know, there's no SSP, statutory sick pay, for the first 3 waiting days of the sickness absence, and there is no SSP for those who earn less than the lower earnings limit, which is currently £125 per week. The new law from April, SSP will be payable from day 1 of the sickness absence and payable for those first 3 days of sickness absence. In addition to that, the lower earnings limit will be removed, which means that all employees, regardless of their earnings, will become entitled to SSP. So those that are currently earning less than the lower earnings limit will become entitled to SSP at a rate of 80% of their normal weekly wages, or the new rate of SSP from April, which is £118.75 per week. Whichever of those is the lower will be their entitlement. So bear in mind that that reform alone will create a situation where more than 1 million low-paid workers will now be eligible to receive 80% of their weekly wages during their sickness absence. Okay, let's move on to collective redundancy. So this is very significant and will be very costly. If you're going to be planning in 2026 to make redundancies, get in touch with us now. This is going to have a big impact. So collective redundancies, currently collective redundancies apply when an employer proposes to make 20 or more redundancy dismissals in any one establishment within a 90-day period. Okay, that's under the Talker rules. And the protective award, that's the amount of money that the employer has to pay the employee for any breach of those collective consultation provisions. It's currently capped at 90 days pay. Okay. So it'd be 3 months. The new law, however, doubles that amount. So it's doubling the maximum protective award for failing to consult in collective redundancies from 90 days pay to 180 days pay. And this change will apply to redundancy proposals made on or after April 2026. And in addition to that, there are also proposals to change the collective consultation threshold in 2027. So more to come. Okay, that's what's coming in April 26. Let's look forward to October 26 and see what's coming in then. So I said earlier, there's more on sexual harassment. So sexual harassment, you'll remember, hopefully, from one of our previous webinars, you'll remember that currently, and in fact, since October 2024, employers have been under a duty to take reasonable steps to prevent sexual harassment from occurring to their employees. Now, the new law extends that duty to prevent sexual harassment by requiring the employers to take all reasonable steps. Okay, so not just reasonable steps, but all of them. Okay, and the reasonable steps are set out in a code of practice. If you want details of that, we've got handouts and all of that. We can put links. Izzy can, if anybody wants it, we can put links into the chat so that you can access all of that from our website for free. So employers need to take all reasonable steps to prevent sexual harassment of their employees rather than just reasonable ones. This is really high impact. One of the biggest things, as well as updating your policies, etc., is training your staff. This means all staff, not just managers and leadership team. This means training everybody to understand what harassment is and what how to behave in the workplace and while at work. So very important, that high impact on every business. Okay, let's look at tribunal time limits. Again, this is high impact. Again, another government headline. So you'll have read about this, I'm sure, or seen this on the news articles. So tribunal time limits next October. Again, this is really, really key and a very high impact change. Currently, most tribunal claims, including unfair dismissal, unlawful deduction from wages and discrimination claims, they must be brought to the tribunal within a 3-month window, within 3 months of the issue that's being claimed. Okay, and this, of course, is subject to a bit of movement if the employee went through ACAS conciliation first. Okay, but the new law, this is really key, the new law extends that. There is an extension to those timelines to bring a claim from 3 months to 6 months. So employees will have from October next year 6 months to bring a claim to Employment Tribunal. This is really key because it's going to simply increase the volume of employment tribunal claims. People have got longer to think about it. People have got longer to get organised, to get their claim prepared, to gather advice. And what that means is, as an employer, you need to get really, really prepared for this in advance. And I'll talk a bit more about how we prepare you, how we get you prepared further on in the presentation. Okay, let's look at fire and rehire. I don't know if many of you use these sorts of practices. A lot of particularly larger organisations do. You may well have read about cases that have gone through tribunals. So currently, this is where fire and rehire is where an employer effectively terminates an employee's contract and then immediately offers to re-engage that employee on new terms that are usually less favourable. So this would be things like lower pay, reduced hours, changed shift patterns, things like that. Now, currently, the Employment Rights Bill bans fire and rehire dismissals completely, particularly where the proposed contract changes relate to pay, pension, hours of work, shifts, or holiday entitlement. Really key contractual terms. But where those proposed changes relate to something else, so that might be, for example, things like place of work. Obviously, you'd use your mobility clause. You'd obviously have that in your contract. If you haven't, you need it. It might be something like job title. It might be duties. And any dismissal for refusing to agree to these changes can potentially still be fair, as long as the employer has planned, spent really good time consulting with the employees, and showed reasonable efforts by following a 6-point checklist. That's not our checklist. That's in the code of practice. If you want to know more about the 6-point checklist, we can share details of that with you. But the key elements of it includes things like extensive consultation with your employees and, where appropriate, offering some forms of inducements to accept the new terms. The new law, however, from next October means that the dismissal will automatically be unfair if the employer sought to vary the contract and the employee didn't agree. So this is really complex. it's going to involve a lot of consultation. And generally speaking, employers that try and rush changes to terms and conditions, and they use fire and rehire practices will almost certainly fall foul of this piece of legislation, no doubt about that. But further details are being ironed out on this. We will jump on more webinars to update you as necessary. Okay, let's look now at third-party harassment. So you've heard me talk already about the sexual harassment and sexual harassment whistleblowing. This now is third-party harassment. Okay, so currently there's no duty on employers to prevent harassment by a third party at work. So this is such as the third party could be a customer, a supplier, a contractor, a visitor. Now, under the new law, employers will be liable for third-party harassment of its employees. The employer will be responsible and liable unless the employer took all reasonable steps. There are those reasonable steps again, unless they took all reasonable steps to prevent such acts. Now, this liability will cover all forms of harassment. So let me remind you what those forms of harassment are. So it's harassment on grounds of age, disability, race, sexual orientation, religion or belief, sex, gender reassignment, and sexual harassment, of course. So if you want to know what the reasonable steps are, again, we'll send you a link to our webpage that covers that. Okay, tipping laws, let's cover this. So tipping laws are relevant in an industry where tips are a significant part of, part of your organisation. So, for example, in the current Allocation of Tips Act 2023, as you know, this requires employers to create a tipping policy. The new law from next year requires employers to consult with employees on reviewing that policy and to review that policy every 3 years. So there's quite a bit to do if tipping is part of your workplace. Trade union rights. Trade unions, there'll be a duty to inform workers of their right to join a trade union, and there'll be expanded union access rights to the workplaces and protection for trade union reps as well. So quite a lot of changes there. Okay, so from 2027, we've covered 2026. Remember, April and October. We're now going to look at 2027. It's important to look at 2027 now because here's the really high impact stuff that's coming through. So first of all, unfair dismissal. This is one of the government's headline changes. Currently, only employees with 2 years service are able to claim ordinary unfair dismissal. The new law means that employees, regardless of their service, once they've started work, will have the right to claim ordinary unfair dismissal. There will be details of what's going to be called potentially an initial period of employment or a probation period. And these dismissals during this period, the period's likely to be 9 months, could be 6 to 9 months. The rules are likely to be slightly softened during that period and perhaps the compensation to the employee slightly lower. But this change is really high impact. It's going to affect every business, doesn't matter how big or small you are, what sector you're in, it will affect all of you. And it's going to be a day one right for employees to claim unfair dismissal. 0 hours contracts. Let's look at 0 hours contracts. So this section that I'm going to cover now is really high impact for companies that employ people on 0 hour contracts, but also those of you that have shift workers and have shift patterns. So currently employees, that's employees, but also workers and agency workers that are on 0 hour contracts have no right to guaranteed hours. They could potentially, the new bill could remove the 0 hours completely by moving it towards guaranteed hours. So this, however, could change to an automatic offering of the guaranteed hours that the employer needs to give to the employee, but the employee could refuse that. So let's look at shift. So if you have shift workers, this is really important. It's likely that where shifts are changed The employer will be required to pay the employee if reasonable notice is not given, where the shift is cancelled, moved from one day to another, or shortened. And this could include agency workers too. So this is really complex and high risk. If you employ 0-hour workers or shift workers, you need to start preparing for that now. Flexible working. Currently, as of last year, the Employment Relations Flexible Working Act 2024 provided the right for employees to request flexible working from day one of their employment. If you remember, previous to that, employees had to have 26 weeks service, but that was removed. They can now make up to 2 requests for flexible working per year. Now, the new law goes a step further than that. If the employer wants to refuse a flexible working request, it must state one of the 8 statutory reasons that it relies upon, what those grounds are for refusal, and explain why the refusal is reasonable. So you need to get up to date on what the 8 statutory reasons are. Again, we can provide you a list of those. And you need to be training managers now on how to hear flexible working requests, how to move towards flexible working requests, and how to be as flexible as they can to try and say, yes, let's listen to your request. Yes, let's see how we can potentially make this work, or relying on the 8 reasonable grounds for refusal. In addition, in 2027, we've got bereavement leave coming in. This is an extended statutory right for all employees to receive at least 1 week of leave and pay, including for pregnancy loss before 24 weeks. There's also the menopause action plans are coming in. This is for employers that are over 250 people. They'll be required to publish plans on gender pay gap and menopause support. There's pregnancy protection coming in. It'll be unlawful to dismiss pregnant workers or those returning from maternity, except in very limited cases. There'll also be rules and regs coming in for umbrella companies. These are going to be formally regulated under the Employment Agency Standards Inspectorate. Now, there's a lot to understand here. I appreciate that. And it's a lot to do. And it's very complex. So that's why Park City have come up with the 6-step compliance plan, your framework for success. Let me talk you through it. So step 1, first of all, audit and update your contracts, policies and handbook, okay? Making sure they're ready to reflect the upcoming changes in employment law. Include clauses for the day 1 rights, sick pay, parental leave, paternity leave. Ensure flexible working, grievance, dismissal, disciplinary and 0-hour policies are all in line with new expectations. Write a whistleblowing policy if you haven't got one, or update it if you have, and review your sick pay policy, waiting periods, earning thresholds, etc., etc. Step 2. This is where you do a risk assessment and a gap analysis. So do a gap analysis, find out where you may not be compliant now, identify the areas of risk, 0-hour contracts, SSP, unfair dismissal exposure. Assess your current processes. So look at onboarding, performance management, one-to-ones, your dismissal process, grievance process. See where you might need to make changes and prioritise those changes by risk. So legal risk, reputational risk, financial risk. So importantly, more important than ever, is step 3, which is training your managers and your leaders. Much of the business risk that gets to employment tribunal comes through how policies are applied, not just what the policy says. So you need to be investing in training your managers now on handling grievances, how to handle a flexible working request, dismissals, discrimination and harassment. Okay, ensure they understand the new laws as they come in, and make sure that line managers know what documentation, communication and timing is needed to reduce exposure. Step 4 is review your HR system. So if you don't have an HR software system, talk to us. You're going to need it now more than ever. Update it, update your payroll system and your operational practices. So legal compliance, again, often depends on systems as much as paperwork. So check your payroll system can cope with changes, e.g. SSP from day one. Ensure the lower earnings limit is removed and parental leave from day one. HR software should allow for tracking requests, performance reviews, flexible working and grievances, and ensure that internal record keeping is robust. Dates, decisions, how you came to decisions, communications in case of a tribunal. Step 5 is all about communicating and engaging with your people. Transparency builds trust and helps avoid misunderstandings. Let people know about the policies, the new policies, make sure they read them and listen for feedback, and share your updated handbook and ensure they've read and understood it. Step 6 is all about monitoring the law and being ready to adapt. Because many of the reforms are being phased in and some details are still being consulted on, keep updated with the information on the roadmap for the Employment Rights Bill and other changes. Sign up for free updates with Park City. We will keep you updated on everything you need to know. Consult with your HR experts to interpret the final legislation and how it needs to be applied in your workplace, because that will be different from business to business. And build in flexibility so that when regulations and dates are confirmed, you can adapt quickly without delay. Scan the QR code to download our 6-step framework. I think on the next slide, there'll be a QR code. There you go. And also to claim your free full audit of your contract or your handbook. Park City will do an audit to give you, and have a meeting with you to give you feedback on the changes that need to be made and the gaps that you've got. So let's look at an example of how we've used the 6-step compliance plan with a client. So let me share an example of how these 6 steps worked in practice. We recently worked with a family-owned retail business. They had about 80 employees. Step 1, when we first met them, their handbook was 3 years out of date. They didn't have policies that were aligned to things like flexible working, equality, diversity, or the latest family leave rules. So the first thing we did was a full audit of their contracts and their policies. This gave us a baseline of where we were and what needed updating to stay compliant. Step 2, next we carried out a gap analysis. We identified areas of high risk, for example, the way they handled sickness absence and overtime that was exposing them to legal and financial risks. We mapped this out to make it clear where the priorities lay. Step 3, we trained their managers. The team leaders on the shop floor had never had formal training on handling grievances, performance conversations, flexible working requests, and we gave them some really practical tools and the confidence they needed to reduce the risk of problems escalating. Step 4 was their HR records. They were mainly paper-based records in metal filing cabinets, and their payroll system was struggling with manual SSP calculations. We introduced HR software and managed their contracts, which managed their contracts, one-to-ones and absence, which not only ensured compliance, but also saved hours and hours of management time. And then step 5, we then worked with them on employee communication. We updated their handbook, launched it with a Q&A session, shared easy to understand guides so that employees knew about the changes and their rights. And this built trust and reduced resistance. And then step 6, finally, we set up a quarterly review process. This allows us and them to monitor upcoming legal changes, check progress and make tweaks as new employment laws come in. It means they're always ahead of the curve, not scrambling to catch up anymore. And the result, the business is now fully compliant, managers are more confident, payroll errors have been eliminated, and employee relations have definitely improved. And more importantly, the leadership team has peace of mind knowing that HR and compliance are all under control, so they can focus on running and growing the business. So before we move on to the Q&A, which is coming in a moment now, let's just recap And if you remember at the start of today's session, I asked you how confident you felt about navigating these employment law changes. Well, most of the reactions that came through were, kind of shock and horror. Now you feel, I'm sure, you've certainly got a clear picture of what is to come. And also you've now got the 6-step framework that'll help you stay ahead. As you can see, these employment law changes are significant, and navigating them without appropriate HR support will be overwhelming. That's where we come in at Park City. We partner, with business owners, directors, and HR managers. We provide practical, tailored HR and health and safety advice and guidance to keep you compliant, reduce your risks, and focus on growing your business. Reach out to us. Let's work together to make sure your business is fully compliant and fully prepared and confident in what's ahead. So I'll hand over now to Izzy for the Q&A. So if you have got any questions, please pop them in the Q&A now, please. And while people are doing that, I'm sure I think it looks like they've been doing it while in fact, I've been talking. So that's good.
But also, brilliant. That was a great session, Juliet.
Thanks, Izzy. Sorry, over to you, Izzy.
No, you're all right. Sorry about that. We've had a couple of questions sent in earlier on. So just going to kick off with a few. But in the meantime, if anybody else has any questions, please send them in. But Peter actually asked, are day one rights from the start date or from the acceptance of their offer letter? Would you be able to answer that?
Yes, the day one rights are from their start date, not from the date of the offer letter, because obviously you could be making an offer weeks and weeks in advance of them starting and joining. Although we see in the marketplace that period of time is certainly shortening at the moment. But so making sure they've got a contract of employment from day one, and from day one they will be entitled to claim those day one rights, from that point.
Fab, thank you. And then Andrew has also asked that the sexual harassment changes seem quite complex, and where can they get a clearer picture of what we have to do?
Okay, so that's sexual harassment. So we've done a whole webinar on sexual harassment already. So I'm sure that Izzy would be able to perhaps put the link to that maybe in the webinar chat, or we can always send it to you afterwards. But yes, sexual harassment is really onerous, as is harassment. And there is a really clear set of reasonable steps that you must go through to prevent it. And you've got to be able to evidence those steps and demonstrate that you've taken those steps in your business. So that's going to be really important, that you are able to demonstrate you've completed the steps and that employees have in fact gone through them. So if it's doing things like a training course, you need to make sure that you've got the roll call of people that attended, they signed to say that they attended, etc. So you've got the evidence that you can add to your HR software platform to demonstrate that you've covered the steps.
Fab, that's great.
Watch the webinar. There's a lot more detail on that.
Yeah, I put the link into the chat earlier on when you were talking about it. So if anybody needs that link, just head over into the chat. And I've got another question here, but I just want to, because we're running out a bit of time. So if anybody else has any questions, please pop them in. But Gillian's asked that the flexible work request changes. You mentioned there were 8 reasons to refuse a request. What were these?
Flexible working you're talking about, aren't you? I thought someone might ask about that. So yeah, I did just quickly print off the list just in case someone asked. So obviously this is if someone's making a flexible working request. There's a whole bunch of steps that you'd go through when you receive the request. So the manager needs to be planned and prepared on what those steps are. So some of them will be things like, is a disability involved here? Because obviously you need to create a situation where you're not going to create disability discrimination. But to answer the question directly without sidetracking, the 8 reasons for rejecting a request are cost. So will it cost your business too much? Cannot reorganise the work among other staff members. You can't recruit more staff. It's a difficult market at the moment, isn't it? There'll be negative effect on the quality of the work. There'll be a negative effect on the business's ability to meet customer demand. There'll be a negative effect on performance. There's not enough work for your employee to do when they've requested, when they've requested to work. So if, for example, it's quieter at the end of the week and they've requested to work, at the end of the week, then obviously there's not enough work then for them to do. And there are planned changes to the business. So if, for example, you're about to go through a restructure, for example, that might be a reason to refuse a flexible working request on the basis that things are about to change. Please submit your request in after we've made the business changes. Does that make sense?
Thank you. Yeah, absolutely. So I think we're running out of time. So if I just head over to the last slide, and you can talk a little bit about booking in for an employment law audit, if that's all right, Juliet.
Yeah, great. Well, thanks ever so much, everyone, for attending. There will be a recording, Izzy's recording, so that will be available if you want to recap on anything. But as I mentioned earlier, if you'd like to take us up on the offer of a free audit, should I say, of your either your contract of employment or your company handbook policies, then scan the QR code that's on the screen now. That will take you through to a Calendly link. And then on that, we can get a copy of your contract and or your handbook, and then we'll go away, do an audit for you and come back to you, with the gaps. And obviously you can, use our team if you wish to get those gaps filled. Thank you very much too. I'm seeing lots of thank yous coming up in the chat. So thank you very much. Brilliant. People sending me messages.
Fab, that's great. So I think we're all finished, are we, Julia?
I think so. Yeah. No other questions coming through at this point, I guess.
If there is, then they can contact us, can't they? And I'll be following up later on today, making sure you've all got the recording. Feel free to share this with anybody, and the same for the checklist. And if there's any other links that you would like, then please get in touch and we can send them over.
Amazing. That's brilliant. Thanks, Izzy. Amazing organisation as always. Thanks for fielding the questions as well. That's great and really helpful. Thanks to all of you for attending, and we look forward to seeing you on the next webinar.
Fab. See you later.
Take care. Bye-bye.
Bye.